Our Attorney General is in the house tonight.
The Dan Yorke State of Mind program is brought to you in part by Lookout Rhode Island and Takeo Comfort Solutions.
Welcome in. The top law enforcement officer for the state of Rhode Island, true to his campaign promise a couple of years ago, always available to talk shop. And actually, we scheduled the Attorney General in kind of on a, hey, it's been a little bit, so let's bring him in, and then stuff happens. So I'm going to forego most of the commentary on all things crazy in the world. Unless the Attorney General wants to offer his medical expertise on the coronavirus. I'm not sure. He is trying to expand the operations of the Attorney General's office. But first, welcome aboard. Thanks for tuning in. And of course, timing is everything. We got this press release today that I don't expect you to read, and I couldn't if I tried, at least not without my glasses. But it seems like it's going to be something in the news cycle, and it came just minutes before we were taping the show today. As you know, many of you, that we tape early in the afternoon. That's a clock I look at, by the way. I'm just, in case you're wondering. But the headline on this says, Attorney General charges 19 contractors with failure to comply with the Contractors Registration Licensing Board order involving substandard or unfinished construction work, which is a mouthful, but something tells me it matters to a lot of us. So no further ado, let's welcome in the Attorney General. Thank you, sir.
Hi, Dan. Good to see you.
What's this all about?
Yeah, look, there are contractors that promise to do work for homeowners and don't do it. Or they don't do it the right way. And, the law's not real strong for us there, so we have to work closely with the board to try to get some justice for those homeowners. So, the cases individually, if you were to go up to 50,000 feet, don't seem like a lot, but $8,000, $10,000, $30,000 means a lot to those homeowners. And so the idea here is, look, work it out with the board, make it right, and if you don't, it'll be referred to us by DBR, which oversees the board, and then we'll take action. And that's what we did today.
So, looking at it, and I'm literally looking at it as we speak, it seems to me correct. You got something for 10 Gs, and then 30 Gs, and then 15 Gs, and it seems like it's individual contractors. I'm not going to name them here. You can look it up in the news cycle, because I'd have to do a little bit more homework if I was going to name them. But it seems to me that these were perhaps accumulating civil inquiries on the part of residents or complaints on the part of residents that you grouped together to kind of make a bigger point, seems to me, right?
We do the same thing with gun sweeps or drug sweeps. Yeah, exactly. And look, I think someone might say 8,000 is not a lot, but it's a lot if you're a homeowner.
Hello?
Right? I mean, you got to go get a lawyer, potentially in a civil case, to pursue that. You're going to spend $8,000 to chase $8,000. And don't forget, by the time we get to this point, the contractor has had a lot of opportunities to make it right. They can make it right with the homeowner. They can make it right with DBR and the board. They've basically not done anything. And at that point, we feel like it's appropriate to take action.
So the process, a homeowner says, hey, he promised to change the siding in addition to cleaning the gutters, and he didn't do it.
Yeah, took a deposit of $10,000 or $5,000,
whatever it happens to be. I can't hear from him, I can't find him. The route then is to do what?
Is to go to DBR
the
and the
Department
board.
of Business Regulation.
Correct, because they license contractors. So that's where you file your initial complaint.
And they review that on what kind of regular basis, the DBR?
Oh, I think pretty routinely. And
monthly at least?
Yeah, and then you have a hearing before them, and you're given notice, the contractor's given notice, they have a chance to present their side of it. And then an order issues from DBR or the board and says, look, you got to make it right. When the contractor doesn't make it right, when they don't comply with that order of the board, then it comes to us for prosecution. There's a more direct way to do this if our consumer protection statute was what it should be, but it's not. We're trying to change that. The Attorney General...
Do you have a law pending or a
bill
pending, filed?
Right, because the way the law exists right now, for any regulated industry, see these guys, see public utilities, see healthcare, the Attorney General can't do it directly. So we've got to go through the agency, which I think is cumbersome and frankly may limit the remedies we may have when we're doing it. So it's part of a larger conversation about consumer protection. We have one of the two worst consumer protection statutes in the country.
So I'm missing this. So you want to strengthen the consumer protection laws that enable you to do what? Or
to do this directly. So without having to go through the board, have a hearing, get an order, have it be a violation of the board's order that's the
Which
felony.
board?
The Contractors Registration Board.
Gotcha.
Have it, so we get consumer complaints all the time. We see a pattern. Contractor A has got complaints from 15 homeowners. We, as the Attorney General, can go directly civilly after that contractor. I think that's much more efficient. And this cuts across any regulated industry, banking, healthcare, public utilities. We can't reach that conduct because it's regulated by another state agency. That's a real hole in our consumer protection.
So with these 19 contractors who have failure to comply with the board's order, are you criminally prosecuting them
Yes.
directly?
Yes.
Because the board has said no mas.
Yeah,
because the board has said we haven't gotten any satisfaction.
Because it is a felony and a misdemeanor to not comply with an order of the board. And then it gets referred to us, right? So we could have handled it civilly ourselves with, I think, a lot of punch had this consumer protection bill.
Would that
in
render the
place.
board useless?
I don't think so. I think the board
Do they
works
want the
really
help?
Oh, I think they do, very much so. I think over the years, the board's powers themselves have been shrunken a little bit. And look, if I think of one consumer complaint that resonates the most with homeowners, it's this issue, right? That you're hiring somebody, you're kind of taking it a little bit on faith. You get your references, hopefully, but you're taking a little bit on faith that the person you're hiring is going to do the work and do it competently.
Biggest risk a homeowner feels like they're taking. It's a lot of anxiety.
And it's their castle. Right.
Right.
It's their castle. It means something to them. They can see it when it's not done
And
right.
especially when a job is half done or something like that, you're chasing, and then contractors don't want to replace other contractors because something's half done and they don't want a piece of that
Right.
liability. Yeah. You know, these things, by the way, seem to be, well, let me ask you, is it your experience that these things happen cyclically? The better the economy, the more risk the homeowner has because the least pressure is on the contractors for the work?
Maybe that's part of it. I mean, the truth is we haven't done a lot of this in recent years. This is kind of a new thing we're doing. We'll see how it goes.
Okay, interesting. So keep tabs on that. You know, it'd be funny. I'm sure that the Contractors Association, there's a bunch of them here in Rhode Island in various groups. They're going to have to stand up and say something about this, seems to me. I think you want a public dialogue, don't you?
Oh, well, sure. But look, you know, again, these individuals had a lot of chances to get it right,
All right.
before we got to this point. And there's nothing, it's like lawyers, right? I'm a lawyer. Bad lawyers make the good lawyers look bad.
Gotcha. Throw out the headline on Harvey. Since we're talking about messages and the Attorney General's perspective on things, just in terms of not the necessary acute criminal prosecution, day-to-day following the criminals in the street. We've got this broad Me Too conversation that's going on right now. Now, obviously, Mr. Weinstein is jammed up on 2 of 5 charges in the Southern District of New York, and he was convicted yesterday, and he'll wait sentence. He could get anywhere from 5 to 20 years, and then he's got another case in Los Angeles. What's your office perspective on what seems to be a new orientation? And do you have a thought on the idea that the jury actually seemed to have crossed kind of a threshold here by being more open to what was a difficult prosecution, seems to me?
Well, sexual assault cases and child molestation cases, by their nature, are difficult cases, and that hasn't changed in the 20 years I've been a prosecutor.
Because?
Well, sometimes it's, you know, it's...
Other than the nature of the
Well, there's
what's
that, and then
alleged.
it's typically one person's word against another. There might be some corroborative evidence, but many times there is not. You know, in child molestation cases, your victim is very young, may not be able to testify at all. So anyone who's done this for a long time knows going into it that sexual assault cases can be difficult to prove, and for obvious reasons, the victims are traumatized by it. And so it's really important to have a good partner to help in that case. And certainly our own victim witness people are critically important there, but also a partner like in Rhode Island, for example, just one example, Day One's critically important to making sure that the victim is ready to go forward, is there when the bell rings, is capable of telling their story. I give women and men, but it typically is women, but not always, give them tremendous credit for the courage, and children even more so, to be able to tell their story in that environment. It's very difficult. Even when you're interviewing, particularly a child who's been sexually abused, just outside the context of a jury, let alone a grand jury, or a grand jury, let alone a trial jury, a petit jury in public, That's a really difficult conversation to have. I've had those conversations. They're tough. So I give victims tremendous credit for
How
coming
far do
forward.
you want to go in the social conversation here? I had an interesting experience yesterday when the news broke. I went to the first hour of the radio show and asked the question, what does this mean to you? How does this view the way you see yourself and others and how they behave? Didn't know exactly how I wanted to address men necessarily. And the phones are very quiet until a woman called at the end of the hour and she said, the reason why the phones are very quiet is because men don't talk about this stuff.
Yeah.
Women talk about it in groups and in therapy and
Right.
in just social settings all the time.
Right.
Men don't speak about it.
Yeah.
I'm not asking you to be the super counselor of the state, but do you
Sure.
have a perspective on that?
Well, look, I have two, really. My wife kind of went through something like this when she was a resident. Someone who, wanted her to do research, not because of her ability, but because of the way she looked. And so she still remembers that 30 years later. My wife's really tough, but still remembers it. So I have that personal perspective, but my own perspective is, look, every professional environment I've been in, professionalism has been first and foremost. I think as a man, our role is to call it out when we see it, and certainly, but as a leader of an organization, is to create the culture where that stuff's not tolerated. It's not even thought of. It's not a joke. It's not funny. That we are professional. When I was going through my transition, I wrote a letter to everybody on the staff to try to lay out what my vision was for the office. And professionalism was the first word that I used. It cuts across a lot of things, but this is part of it. If you're in a professional environment, then this kind of conduct isn't tolerated. And the kind of conduct that can lead to the conduct isn't tolerated.
That's not a law enforcement organization perspective. That's an organizational
Correct.
perspective.
Yeah, correct.
Period. Interesting. All right, when we come back, the Attorney General's thoughts on the Department of Justice and some of the tumult that happens to have been going through. And of course, there are a couple of local stories. Stay with us. Your phone. All right, so take a look at this summary of our U.S. Attorney General and some of the stuff he's had to deal with.
President Trump is not taking his Attorney General's advice to back off when it comes to tweeting about the Department of Justice, demanding justice for himself this morning and retweeting a call on Attorney General Barr to clean house at the department.
Yeah, I do make his job harder. I do agree with that. I think that's true.
CBS News has learned that Barr was so fed up with President Trump's Twitter habit that he considered resigning, but sources say things have cooled off for now. The president defended his recent pardons and commutations, including former Illinois Governor Rod Blagojevich, convicted of trying to sell Barack Obama's Senate seat after he became president. Mr. Trump argued Blagojevich did not sell the seat, and his move prompted thanks from the one-time Celebrity Apprentice contestant today.
I'm a Trumpocrat. The Trumpocrat, that's right.
Are you going to vote for him?
If I have the ability to vote, I'm going to vote for him.
Meanwhile, the family of Paul Pogue, whose sentence Trump also commuted, has given more than $200,000 to the president's re-election campaign. And prominent GOP donor Nelson Peltz, who hosted a $10 million fundraiser for the president in his Palm Beach home, pushed for the pardon to junk bond king Michael Milken.
All right, pardons and that kind of thing aside, more tumult. You've been, I think, pretty eloquent about the Justice Department and, your perspective as the former U.S. Attorney. 2,000 former DOJ employees pen off a letter suggesting that the Attorney General resign based on this thing going on with Roger Stone and that particular discussion where he reportedly upended his own staffers in a sentencing recommendation at trial. Were you asked, by the way, to participate in that letter?
No, I wasn't. Some of my former colleagues signed, actually, but I wasn't asked.
Got a take?
Oh, I think it's concerning. What I found two things concerning. Number one, that 4 AUSAs would step down. Actually, the New York Times did some more reporting on it, I think, in the last 24 hours. But 4 AUSAs would step down. That's an extraordinary step. Extraordinary. So, because
And assistant U.S. attorneys are really the operations people of those offices.
Oh, sure.
They are handling cases.
Yeah, this is the Washington U.S. Attorney's Office. It's 300 people. They do all kind of the state-like prosecutions there and the big federal ones. So they're combined in one office. It's a huge office, one of the biggest in the country, because there's no state system there, obviously. So for AUSAs, look, I was driving my office. There were cases sometimes where I drove prosecutors maybe to back off a little bit or be a little more aggressive, because that, I think, was my role as U.S. Attorney. No one ever wanted to get off a case. So for an AUSA to get off a case, that's extraordinary, and sends a very powerful message about what they think's going on. I think the other thing that really caught my attention was the U.S. attorney down there that was pushed out by the president, who appointed by this administration, but I think if you're looking at her objectively, she should have been, and I believe was, a good U.S. attorney. And the president pushed her aside initially, or Barr did, and then withdrew her appointment to the Treasury, apparently over the Stone sentencing recommendation. And then they go in for the Stone sentencing, and as I read the reporting, it's very confusing. They stick by the original memo. So I think it is a state of tumult down there, and I think morale has to be bad.
Meaning the prosecutor who actually addressed the judge at sentencing stood by the work of the career prosecutors who had originally asked for 8 to 10 or 9 to 10
Correct.
years. I'm sorry, 7 to 9 years.
Correct.
And seemed to have been doing a save for those guys. And who knows whether that was in contrast to whether he was conflicted or told the boss, I don't care, I'm going in, I'm going to save this thing, or whether Barr wanted him to go in there and resave the thing.
Or the directive changed. We don't really know.
The tweet happens, the president's upset with just the whole concept of Stone going to jail, and immediately thereafter, the Attorney General has a lesser sentence memo refiled. It was
bad move.
A really bad move.
Bad move. Extraordinary.
All right, well,
I cannot remember even something even remotely similar to that. I can't remember anything like that happening. It's extraordinary. Terrible.
As U.S. attorney here, and to as much of an extent as you can, because you're now an elected official in your current role, to your credit, you have articulated a space between prosecutorial process and politics.
Sure.
This completely blurs the line.
Oh, it eviscerates it.
Should he resign?
Barr, if this storyline that we've described is accurate, that if he changed the department's directives because of what the president asked him to do in a tweet, he should resign, yes.
He would suggest he didn't, but he did then suggest that the president's tweets aren't helping him do his job.
Yeah. It's very odd, Dan. It's very odd. I really grieve for the department. I think that at some point, this department is going to need the kind of in-depth makeover like it's never had before. The Justice Department is built to withstand changes in administration and different personalities among presidents and different policy directives and priorities. It wasn't built to withstand this. It may be able to withstand it, but it's not going to be easy. It's not going to be easy.
Whole bunch of stuff in Rhode Island not easy right now. Next.
I can answer all their questions truthfully and honestly, and I saw no wrongdoing with this matter.
That is Frank Montanaro, the executive director of what's known as the JCLS. I wish I had time to explain to you, as I have in other shows, exactly what that is. But suffice to say, it's the administrative arm of the General Assembly. The Speaker of the House is immersed in this controversy where he reportedly ordered Mr. Montanaro to have the Auditor General, who reports to the House of Representatives, to audit the Convention Center Authority. And if you believe the reports, some which I have sourced to you, that it was motivated by a favor for a friend of his who was the security guy at the Convention Center who was jammed up on a personnel matter. He is no longer there. Your policy is not to confirm or deny grand jury proceedings, but it's hard to ignore people walking in and out of the Kent County Courthouse. So your status report on this investigation, which clearly is looking at the Speaker of the House, is?
I can't confirm or deny the investigation. You know, it's I know that has an Alice in Wonderland quality. That answer does. I get that, but I have to follow the rules, and I follow them. And so, you know, people are free to talk about what may or may not be going on in a grand jury. The only people who can't talk about an investigation, I'm speaking generally here, are the law enforcement, prosecutors, the stenographer, and the grand juries themselves. It's actually a crime for us to talk about it. So we don't talk about it. We don't confirm it.
The current grand jury sits, sits through February, I think the schedule is. Will it be extended, or is it going to wrap up?
I can't say that one way or the other. I will say, generally speaking, we extend grand juries. Did it federally, did it state as necessary. You know, these sometimes cases take. You know, they don't always go fast, and particularly when cases are investigatory in nature. And I've done a ton of those over the course of my career.
The Speaker is also implicated in the Jeff Britt trial. We have a headline there, which reportedly is, according to the accused, Jeff Britt is the political operative who is charged with a money laundering matter in the 2016 election that saw Nick Maniello re-elected. You're past the grand jury there, and he's indicted. You had a press conference announcing the indictment.
Sure.
Where does that case stand, and what of the new news this week that he has petitioned the court to demand that you turn over grand jury testimony that he says he's waiting for?
The case is in the discovery phase. You know, I don't want to sort of get into.
Have you been tardy? Has the office been tardy?
No.
That's the implication.
Yeah, I understand. And look, I prefer to speak in court, but let's just speak generally. You're entitled to the grand jury tapes. In all of our cases, including this one, the defense got the grand jury tapes in timely fashion. We're under no obligation to transcribe them for the other side. Sometimes we do it as a matter of courtesy, but we're not obligated to do that. Our obligation is to give you the tapes. That's a testimony. The defense has that material, so we'll respond in court. But I'm not concerned about that.
Timing on this case to trial? There's another hearing in March.
Yeah.
Preliminary. If he takes it to trial, timing?
Hard to say. Up to the court. We're prepared to try it at any time.
Does the grand jury proceeding that you can't come in exists have anything to do with the timing of the Britt trial, since they're both seemingly involving the Speaker of the House?
Well, it's a clever question, but the Britt trial will go forward when the court's ready to try it. But we're ready to try it. So whenever the court's ready to try it, we'll try it.
The Supreme Court just issued an interesting edict over the 38 studio situation. I only have a minute or so here. You supported the Supreme Court's decision not to release grand jury testimony based on the governor's request for that to happen. I don't think you did it because you don't want people to know what's going on. I think you agree that the Supreme Court read the current law as it stands.
Yeah, sure. Look, my job is to follow the law. I don't do mental gymnastics when it comes to the law. When the law is as clear as it is here, and it's abundantly clear, then we follow it. It's not a matter of discretion. But I also think it's incumbent on us to have a fix. If I feel that maybe information in a certain case ought to be publicly disclosed, I ought to propose a fix. And we proposed that with our grand jury report statute. Brought it up there last year, didn't get it over the finish line. It's up there again this year. And hopefully we'll have a good debate over it, and hopefully the legislature will pass it.
All right, so it's really in the legislature's hands in order to be able to remedy that particular saga. I only have 20 seconds here, though. 38 Studios finally seems like it's kind of in the rearview mirror, but the impact isn't.
Yeah, look, it feeds into Rhode Islanders' cynicism of their government, which I understand. I mean, you know, we don't have the greatest track record of getting things done right, even when we're trying to. On the other hand, there's a lot of good things about the state, and we should reflect on that a little more.
Appreciate the visit.
Thank you, Dan.
Final word next. Okay, we try to get some answers on some of those local stories from the Attorney General, but of course, there's no comment. Believe me, there's plenty going on, and when the grand jury resolves one way or the other, we'll have a more clear picture as to how the Speaker of the House is doing. I'll see you on the radio tomorrow at 3 and back here tomorrow night. Have a great evening. Bye.